Hello and welcome back to my channel Kotse. Today I have come before you with a peculiar issue which had come before the Karnataka High Court. There is a saying that you are known by the conduct you do in the society, and when you are a power charge or is in a position of power, it is how you conduct yourself by using those powers or position is really an important aspect. I'm not talking about any politicians or a bureaucrat, or for that matter big corporate honkos. I am talking about a normal person who is in a peculiar power position and how he conducts himself in a public domain. That's the whole sum and substance. What has happened here is this: a borrower who had sought some financial assistance from a particular bank. Basically, this borrower was a director in the company. There were two directors, the father and the son, and the son had borrowed a huge amount of money from some bank, and before it was repaid, the son died. And after the son's death, the father of the son, that is the deceased son, honestly, to show his bona fide, came forward and approached the bank to repay the entire amount. This was an honest attempt by the father. The bank conceded that, and they did accept the proposal to receive the payment. Obviously, the bank was in no way to deny the payment. Father did pay some amount, and then thereafter the pending amount he sought some time extension. In Ombudsman's scheme, the one-time settlement proposition, he sought some time, which bank eventually denied, and that is how the issue landed before the court. Ultimately, court gave some extension after understanding the whole bona fide and the conduct of the father of the deceased son. And it was a huge amount. Basically, the father had already paid a substantial amount. The only balance, which was not much, though he was suffering from some financial constraint, yet he managed to pay. But only the balance amount which he had to pay, he sought some time, the bank denied. That's how the proceedings landed in the court, and the court understood the entire concept of the genuineness of the borrower's father. And then eventually the court conceded and allowed the petitioner's relief and extended the time. And that's how in extended time the father repaid the entire amount with whatever interest which was applicable. The entire amount was paid. Now catch is here. After the repayment, the bank had to issue him the no due certificate and return his title deeds of the mortgage property, because it was a secured loan. The loan was against the property, the mortgage loan. Now the bank did issue the no due certificate, but kept it on hold and did not return the mortgage property's title deeds to the father of the son, on the pretext that they can only hand it over back to the person who has borrowed the loan. Now this was really a bizarre condition where the bank was denying to return the property document on the pretext that they can only return back to the son who borrowed the money, knowing very well that the son is no more. He has died, he has committed suicide. And the father had suo motu came forward and wanted to repay the money which is he has already repaid. And that's how the 85-year-old father takes the entire issue before the Honorable High Court Karnataka. And after understanding the entire pleading, High Court was very amazed with this conduct. It was really unprofessional, rather inhuman conduct by the bank officers who were involved into this entire mechanism of receiving the funds, repayment of the funds and the return of the property documents. But somehow the bank officers were coming with some excuses through their lawyer, saying that it can only be returned to the son and the son is no more. And this was a laughable proposition. The court obviously did not accept that, asking how can you return the bank document to the person who is already died. You can't do that. You can only return it to the legal heir, and the legal heir here is the father, and the father has paid the entire amount. So you have a locus to repay, return back the property document to the father only. I mean, you can't go to the heaven and give the property document to the son who has died. And after all the arguments and pleadings from the rival contentions of the lawyers appearing, the High Court not only allowed the petition and directed the bank to return the property document forthwith, but also imposed a heavy cost, approximately 2 lakhs rupees, on the negligent officers of that bank. And that was a bizarre situation where the High Court has to deal with such kind of situation, which at the first instance should have been resolved foremost at the bank's level only. And the bank had no business to retain the property document despite receiving the entire amount from the legal heir. And the bank should have returned back the property document to the father. But needless, the wisdom did not prevail, and that's how the legal issue landed in the High Court. And the High Court, rightly so, directed the bank to return the document forthwith to the father. This is the recent development, probably just a day before yesterday, and I came across this judgment and thought of sharing with you guys. I hope you have liked this video and keep on watching my video. I need your support and blessings. Thank you very much for watching this. See you soon with some other subject and some other topic on the legal issue. Thank you very much and have a nice day.